Okay, in this video I want to just explain to you why you should make a will, and sort of what happens if you don't, and also what you should put in your will. So if these things are of concern to you, or you've thought about them at any stage, the video should help. Okay, the first thing is, the reason why you might make a will is because if you don't, the state and the legislation and the rules of the superior courts and the Succession Act of 1965 will determine A, who gets what, in other words, who will benefit from your estate, and it'll also determine who is in a position to extract a grant of administration for your estate. So when you pass away, particular rules will kick in, the law will kick in. It's basically an intestacy situation, and somebody then will have to extract a grant of letters of administration to look after your estate. But without a will, you're not having any say in that. It's a question of a particular hierarchy that's set out in the court rules and in the legislation. So that's why you should make a will. What should you put in your will? Well, basically you need to decide who gets what. So typically you might have, or I might have, a husband and wife or partners coming in, and most of the time they will create reciprocal wills. In other words, one party, one spouse, will leave everything to the other spouse, and vice versa. Then if there's minor children, or even if there isn't minor children, they may make, or they should make, provision for when both parties, both spouses, might pass away at the same time. Now this is obviously very unlikely, but it can happen in a catastrophic accident, for example a car crash or an airplane going down or something of that nature. So you'd make provision for that, the eventualities, I say, of everything not going to the other party simply because you both pass away at the same time. An extra concern here would be the whole question of minor children. In other words, if you have minor children, you want to make provision. Clearly, if you pass away, or when you pass away, the other spouse is going to be the guardian and trustee of any minor children. However, if both of you pass away at the same time, then you need to consider in your will who will look after the kids, basically, when you're both gone. Who will act as guardian and who will act as trustee. A trustee generally looks after the financial stuff for the children, and a guardian would look after the bigger decisions, like questions about education, religion, perhaps medical decisions, if if some of the children have to go to hospital or whatever. Now, you can actually make the same person or people executor and guardian and trustee of your will, or you could have a guardian, a separate guardian from trustee, or separate again from the executor. But these are the type of things that you will be putting in your will. So essentially what you want to do in your will is decide who gets what, who will act as administrator or the executor of your estate, and who will look after any minor children if, God forbid, both parties go at the same time. If that doesn't happen, if you don't make a will, then there are possibly tax implications, and there is the problem with the court's rules and the legislation, the Succession Act 1965, determining who gets what and who has an entitlement to extract a grant of administration to look after your estate. That's it. I hope you find this video useful as to why you should make a will, what should be in it, and what happens if you don't make a will. If you have any comments or any questions, just leave them in the box down below, and I will certainly reply if I can. I will reply, and I'll answer your question if I'm able to. Alright, thanks.